Citizens Court is now open. You may be seated.
Good morning.
SJC-11596, Commonwealth versus Stephen Foster.
Good morning, Mr. Kern.
Good morning. May it please the Court, Dana Kerhan representing Stephen Foster. In this case, Foster committed the murder and robbery, and we're not going to argue otherwise. What we contend, however, is that the search warrant affidavit, which was submitted very early in the investigation, failed to establish probable cause that either that Mr. Foster was involved or establish a nexus between the crime and the location searched. The information recited in the affidavit indicated that a gun possibly connected to the killing, a green bag, some money, a pair of sneakers, and some clothing had been found a short distance from the gas station that had been robbed. And at that point, the police had no information that Foster had been in the area or had the means to get into the area. He did make some statements when he was taken to the hospital that indicating that his pants and his sneakers had been stolen, and that he had talked to two people who had tried to sell him a gun, who had then hit him and knocked him out.
Well, isn't it fair to conclude that the items that he essentially said were his were indeed items found nearby?
It probably was
murder?
That's probably a fair inference. But I think...
And the story was, well, pretty fantastic.
His story was pretty fantastic, but I think what they, at that point, he was potentially the person who had done the robbery, potentially a person who had information about the robbery, and potentially a witness to some aspect of the robbery. And at the point that they executed the search warrant, and as the investigation progressed, obviously they got more information linking him to the crime and solidifying things. But at the point that they obtained the search warrant, they really had insufficient information. All they had really was a hunch.
The Commonwealth says that the search warrant doesn't have to specify reasons supporting probable cause to believe that he was involved. Do you agree with that argument?
I don't agree with that. I think if he was just a witness, or if he was cooperative throughout. If he was a witness, that's something that they probably could have established. But if all he was is a witness, and if they had no probable cause to believe that he was involved, they really had no reason to go and search that location. I understand that the Commonwealth says that, they didn't have to have any information that Foster was involved. They just had to have information that evidence would be found in the room. Well, the only thing connecting that room to the killing was Foster. I mean, there's nothing independent. They didn't have information that somebody saw a gun in that room or somebody saw evidence in that room. We don't know who lives there.
But Foster was connected to the particular items that were found rather quickly after the robbery behind the station. So,
and the timing.
doesn't that make a difference to you?
Well, doesn't make that much of a difference to me. It might make a difference to this court, but I don't mean to be flip. I think obviously, they had a hunch, and the hunch was right. They found the evidence. They found very powerful evidence when they went in and executed the search warrant. But at the time, my point is that at the time that they obtained the search warrant, all they had was a hunch.
Well, is that really all they had? I mean, they had the timing too, right? I mean, the robbery takes place at 10. Things are being found. They see this fellow at the same hospital at 11, right?
That's right.
So, and he tells them when they come upon, isn't it that like at least between 10 and 11 he was back at his rooming house?
That's probably a fair inference. He says that at 8:30 that's when he was attacked.
Right.
But he does give a very specific description of two other men, and there was, it turned out to be, not the case, but the police didn't know that at the time. What they did is they focused on him and said, okay, look, here's our guy.
Well, it doesn't seem unreasonable that they would think that there might be evidence of the crime in the room, given the timing and the items that were found.
When you look at the search warrant affidavit, there's not a lot there. What they do is
Well,
they...
isn't that there? Aren't the times and the items?
Well, the items are there, and they talk about the robbery, they talk about the items found behind the scene, then they talk about Foster's story. And I don't think they, I'm not sure if there's any discussion in the search warrant about the timing. Obviously, there's probably some inferences that can be drawn, but I'm not sure if the inferences really carry the day here. And I think my point is that if we were looking at a breaking and entering, and we were and we weren't looking at a very terrible murder here, I think we might look at this search warrant and say, this is a little bit weak and this is probably deficient. At the time, they
Well, it's not the best, but all it has to be is good enough, right?
That's right. And my point is that it's not good enough. And it was, in the circumstances, it was deficient, and whatever was found in the room should be suppressed. The second point I want to argue is under 27833E. I'm not asking for a lot of sympathy for my client based on what he did, but there is substantial evidence that he had a lot of physical and mental problems prior to this. He was actually he has Guillain-Barré syndrome and spent 3 months in a medically induced coma. He had to learn to walk again.
When was that in his life?
That was a couple of years before the robbery. But it's sort of ongoing. He's not, it's something that doesn't, it can be treated, but it can't be cured. He also, he was...
Sorry, and the symptoms from that are, do we know that?
The symptoms are that it can be up to complete paralysis.
But how would that affect mental state at the time of the crime?
Well, that's part of it. I guess my point on that is that he had a very difficult time beforehand, and it really made a mess of his life. But in addition to that, he had some very serious mental illnesses. He was committed to Bridgewater, where they found that he had severe depression. But there's also reference to I believe it's a 2006 diagnosis of bipolar disorder, severe depression, and PTSD. And given his mental state, I would suggest that this is at least something that could be considered as a mitigating circumstances, and may warrant the reduction of the verdict to no more than second-degree murder.
Remind me, counsel, was the defense in this case was identification, ID, or misidentification, I should say, right?
That was, well, I guess the defense was that that the police didn't do a very good job of investigating. They had these two men who talked about, who he identified, and they never followed up on that. They just focused on him and decided he's the guy and did nothing else.
So I guess what I'm trying to get at is mental incapacity was not really part of the defense.
It was not part of the defense, but there was evidence brought out during the proceedings, and I think everything I cited on his mental illness is in the record.
Okay.
Unless there are any further questions, I'll leave the remaining points to the brief.
Thank you, counsel.
Thank you.
Good morning. May it please the court. Sebastian Pacheco for the Commonwealth. The court should affirm the magistrate's decision to grant the search warrant because the accompanying affidavit provided substantial basis in regards to the probable cause standard as set forth in Commonwealth versus O'Day and his progeny.
Now, don't we need to find probable cause to believe that he was the shooter in order to find probable cause to believe that there was evidence in the room?
According to the case law, Justice, I do not believe that you have to find.
Well, I know in theory it is. In theory, one could imagine a situation where there's probable cause to believe there's evidence in a room without necessarily believing that the shooter lived in the room. But in this instance, would there be probable cause to believe you'd find evidence of the shooting in the room if he were not the shooter?
Well, in this instance, the affidavit, I believe the affidavit was actually very substantial. It was a three-page affidavit, and it did contain substantial facts, and there were substantial reasonable inferences that could be drawn from the facts to tie the defendant to the room in a very timely fashion. In fact, the shooting took place in Taunton, and the room was also that he lived in was in Taunton, which was at most 1 to 2 miles away. The timing of when the ambulance came to pick him up and to do the first evaluation on his medical status was at 11 p.m., which was only 1 hour from the time the shooting happened. So by his own admissions, the defendant placed himself at the room within 1 hour of the robbery and the shooting, which without any other explanation of where he had been that evening, was the only place that he would have had to gone back in a very timely manner, and any evidence that he would have carried back, which would have been either the proceeds, the ill-gotten gains from the robbery, or the biological material, or the soil samples that the police averred to in their affidavit that they were searching for. So it was a very reasonable inference for the magistrate to make that the ill-gotten gains and the evidence that would tie this shooter to the robbery would be back at the boarding house. And in fact, there is a case, Commonwealth versus Sinelli, which also involved an armed robbery and a shooting, where this court made the direct holding that in armed robbery, these types of fruits and these types of implements in an armed robbery could be tied in a timely fashion back to that dwelling place within 5 days of the arrest.
I take it here, first of all, in the affidavit, the defendant essentially admits that he is very much related to all of the evidence, including the clothes and the rifle that was discovered behind the scene of the robbery. Right?
Yes, Your Honor. The defendant spontaneously brought himself to the attention of the police and established all of the connections to this investigation himself, spontaneously.
And that was in the affidavit. So
That
you
was-
have a connection of him to the evidence left behind, probably by the perpetrator, and then the timing as well.
Yes, Your Honor. And the police did not apply for an affidavit for the search warrant immediately. There was actually 2 separate interviews that took place several hours apart by the police as the investigation continued, where the police went back and asked the defendant more questions about his original story, where the defendant then added details to his story and made some slight contradictions with his story as well before the police decided that this defendant was a proper target for the investigation.
And when he called in for this sort of 911 call and to sort of tell this story, he was back at his place.
Yes, he was, Your Honor.
Am I correct that at the time of the search warrant affidavit, they had not yet ascertained the amount of the loss? Because there's no reference to the amount of the loss in the affidavit.
You're correct, Your Honor. There is no record to the amount of the loss. The investigations were taking place at 2 locations simultaneously. The police were at the Planet Petroleum, the gas station, which was robbed, interviewing witnesses, which did include eventually the owner, who verified the amount, which was $1,040 that was taken and missing from the proceeds that evening. And simultaneously, because the police had accompanied, ironically, the victim himself back to the Morton Hospital to do further investigation, that is where they encountered the defendant himself, because that is where the defendant chose to go to when he sought medical attention.
Was he taken by ambulance?
He was taken by ambulance, Your Honor, and the ambulance ride was only about 200 feet from his dwelling place. And when the EMTs showed up and they did their initial evaluation of his physical status, they found nothing wrong with him. But of course, according to protocol, they asked him if he would like to go back to the hospital, which he then climbed into the ambulance under his own power. This is all in the testimony at trial. He climbed in under his own power and rode the 200 feet back. He was, again, extensively examined, both physically, and there was a CAT scan to search for internal trauma to his brain, which might be consistent with the beating that, according to the defendant, had caused him to go into unconsciousness for approximately 1 to 2 hours. That's never been verified, but
During which time his clothes were stolen.
exactly, Your Honor.
And he had scratch marks on his ankles.
He did, Your Honor. When the second interview was done at the police station, those officers that did that investigation noted that he did exhibit scratch marks, some kind of scratch marks on his legs and on his neck, which they considered to be consistent with someone who was walking in the woods, perhaps without shoes.
Did they have at that point the information about the person who'd seen him at the CVS?
Not at that time, Your Honor, no.
Could I go back to your point on page 18 of your brief that the warrant application does not have to show a nexus between the defendant and the crime? Why would the evidence be in his room if he didn't do it?
Your Honor, again, the review of this, whether or not it was proper to issue the affidavit, does go by a case-by-case basis. According to the standard set forth in case law, that is not one of the elements that is specified in the probable cause of search standard, but without stating whether or not that should be the case. In this case, the facts that were averted in this affidavit and the reasonable inferences that could be drawn from this case, the Commonwealth's position is that there was more than enough to establish probable cause for the police that this defendant was in fact the target of this investigation, properly so. One thing I have not mentioned yet was the police, at the time that they applied for the affidavit, for the search warrant through the affidavit, they also believed that the rifle that was found in the woods had been obtained from the shooter from a housebreak that had occurred only a few days before in Taunton. And they put that in their affidavit, and after interviewing the defendant in this case, they checked the defendant's criminal record, and he exhibited a criminal record that had a history of breaking and entering, which caused them, again, to believe that he might be involved in the earlier breaking and entering, which further supported that they thought he might have been the one with the gun. And since he had given them such a strange story that tied them to the gun, it also supported their suspicion that he was the actual shooter in this case.
Was there ever any evidence to indicate that Mr. Foster knew the victim, that the victim would have recognized him?
At trial, there was testimony from his ex-girlfriend that she and Mr. Foster and their child together had visited the Planet Petroleum on numerous occasions, and she had witnessed him interact with the victim on those occasions.
And there were no masks or anything found in the woods behind?
No, Your Honor, there were not.
So I assume the motive then is that he realized the person would have known who he was?
Yes, Your Honor, that is one of the motives that was argued in the closing arguments of the Commonwealth.
What is your position on 33E relief?
Turning to the 33E issue, Your Honor, this court has stated that the fact of mental illness in and of itself just generally does not warrant the reduction of a verdict. The Commonwealth contests the defense counsel's characterization that there was substantial evidence in this case of a mental disturbance. In fact, the only evidence of any kind of mental illness of the defendant comes from a Section 18 evaluation that was a pretrial evaluation that came onto the pretrial record when the defendant moved to be committed pretrial to Bridgewater Hospital. Now, that evaluation was done of the defendant, and the Commonwealth concedes that he was diagnosed with major depressive disorder. However, the lengthy evaluation repeatedly says that he did not suffer from any psychosis, he did not suffer from any delusions, he did not suffer from any mania.
What about earlier? I know that you're saying that this was situational and that it postdates the arrest. But what about, I thought counsel just said that he had been diagnosed as bipolar and as having suffered major depression prior.
Yes, Your Honor. The 2005 diagnosis that is referred to in the Bridgewater evaluation and has been referred to here today was a self-reported diagnosis that the defendant made when he was being evaluated at Bridgewater. There was no documentation substantiating such diagnosis, and in fact, it states in the Bridgewater evaluation that when asked the name of the doctor who had made that diagnosis, the defendant could not remember the name. So it's an unsubstantiated diagnosis. And actually, the only time this came in at trial was when the defendant exercised his right not to testify at trial, and a colloquy was done to make sure he was taking that position voluntarily and knowingly. And the judge asked him about the Bridgewater evaluation and noted that he had been diagnosed with major depressive disorder, and specifically asked him if that was mostly caused by the circumstances of being prosecuted for this case, which the defendant did answer affirmatively to.
Thank you, counsel.
Thank you.
If there are no further questions, the Commonwealth rests on its brief. Thank you.